Okay, welcome everyone. So exciting. I'm sad that we're not in person this year because this is one of our biggest events where we all get together and get to see each other. But thank you for attending our digital education program. I am Jennifer Richardson, your CAI California North Chapter 2020 president. I'd like to give a shout out to my fellow board members, John Hanson, Scott Hubbard, Jeff Brown, Mark Glassberg, Miranda Ward, Richard Navarez, and who's leaving us after this year, Dan Young. So thank you guys all for your hard work. The board has spent a lot of time making sure that we are communicating with you guys during this whole COVID situation. And if you ever have any chapter questions, please feel free to reach out to any of us. We couldn't make any of this possible without our event and sustaining partners. So we'd like to give a special thank you to those partners who have donated their sponsorships for events that could not occur during 2020. We would also like to invite you to follow us on social media. The chapter can be found on Facebook, Instagram, Twitter, YouTube, and LinkedIn. And I know a lot of these recorded programs go to YouTube. So sign up for and follow us on YouTube. We are going to let our event sponsors have just a couple of seconds to say hello. So when you hear your company name, please introduce yourself. Today's event sponsors are Action Asphalt Paving and Maintenance. Is there anybody here from Action Asphalt that would like to say hello? Okay, Action Property Management. Broadband Agreements. Morgan, I know you're here. I see you.
Yeah, thank you, Jennifer. Yeah, Terry and I are both on. We can't thank you enough. We wish we could be there in person, but thanks to everybody. We're still operating. Terry and I are busy dawn till dusk. So please, these cable agreements come up, please let us know. We'll help you. So thank you all. Looking forward to the program.
Thanks, Morgan. Heritage Bank of Commerce. Anybody here? Okay. Here we go again. I don't know if I'm going to say this correctly, so if someone's here from this group, please speak up and correct me if I'm wrong. Riley Pasick Canty LLP. Rachel, am I wrong or right on that?
Okay. I was right. I thought I saw Danielle calling her out.
How about the GB group? GB group.
Hello, everyone. Good morning. This is Megan with the GB Group. We have partnered with industry experts to provide a one-stop shop for all your SB 326 deck inspection needs. So please call me if you have any questions. Thank you so much.
Thank you, Megan. Thank you to all of our event sponsors. We certainly appreciate you. And then, of course, our other rock stars are registration sponsors. Today's registration sponsors are Adams Sterling PLC, Alliance Association Bank, Angus and Terry LLP, Associa Northern California, Vidalin and Jacobson LLP, GP Landscape, Heritage Bank of Commerce, Pacific Western Bank, Popular Association Banking, Real Manage, River City Restoration, and Social Insurance Agency. Thank you to all of our sponsors, and we would ask that you guys please consider our sponsors when you're planning projects or need help in your community. So now we will go on to a little bit of housekeeping. As Rachel mentioned, we are recording this program. It will be available for view on YouTube shortly after the program. We ask that you please keep your microphone on mute. It's okay if you want to leave your video on. And we will be taking questions via the chat function at the bottom of your Zoom screen. And finally, if you guys want to stick around and visit and socialize a little bit after the program, we will be doing an impromptu networking session immediately after the program ends. You'll be able to turn on your microphones and visit, so please don't sign off right away. And then following the networking at 1:30, we will be holding the annual meeting. It will be very brief, but if you want to stick around for that, that is open to members as well, and we'd love to have you. So now we will move on to our program. The program, the annual legal update, is being presented by our amazing panel. Darren Bevan of Vidalin and Jacobson and Wendy Benner of Angus and Terry will be serving as panel moderators. And now I'd like our esteemed attorneys to please take a moment to introduce themselves. And Brad, would you like to go first?
Sure. Good afternoon, everybody. And I'm just happy to be here and to be on the panel.
Thank you. And Roger, I'm sorry, Brad is with Angus and Terry. I'll guess I'll give that little bit of information. Brad Epstein from Angus and Terry, and Roger Grant from Fenton Grant Law Firm. Roger.
Hello, everyone. Good to see you all. So just a little bit about me. I've been practicing general counsel and construction defect for community associations for 30 years now. An interesting fact, I've actually kept track of all the board meetings I went to, and I am at 2,742 meetings, and I have 2 more today, and I can hardly wait to attend those. So that's what I'm looking forward to this afternoon and this evening.
Thank you, Roger. And John Hanson with Vidalin and Jacobson. John?
Hi, everyone. I've been practicing for 11 years in community association law as general counsel to associations, advising boards on their day-to-day operations and handling things like new legislation and amending their governing documents. And look forward to today's panel.
Thank you, John. And I will let you guys take it away.
We have our PowerPoint.
Yes, we do. I'm on it.
All right.
Yep.
Well, I'll go ahead and start us off. Thank you, everyone, for joining for the annual legal update. We're going to be covering both statutory updates as well as new case law that affects community associations on a variety of topics. We're going to begin with statutes, and I'll be kicking us off with addressing AB 3182. And I'm going to cover the first few aspects of this law on what it means and how it affects associations. And then Brad's going to end us with explaining the amendment process and what happens if you don't comply. And then we'll move on into some other statutes affecting associations or how they are managed and governed. So beginning with AB 3182, a lot of you may have heard about this by now or read about it. And this is the biggest bill we're going to be dealing with today because it affects so many associations, both now or potentially in the future. AB 3182 addresses rental prohibitions and restrictions for community associations. It amends existing Civil Code section 4740, and it adds a new Civil Code section 4741. So Davis Sterling just got a little bit bigger. The law does a few things. The first is that it limits how you can cap rentals in your community. Associations can now only cap rentals or limit rentals as low as 25% of the community. This makes a difference for associations who currently limit rentals in their community. For example, if you have a rental restriction that caps rentals at 10% or 15%, you will have to take action to comply with this law. For communities in the future who consider adding rentals, and communities are always looking at this issue as they determine what's best for their communities, you're going to be only allowed to go as low as 25%. You could certainly go more. You could have a cap at 35%, which would allow more rentals, but you cannot limit them any longer lower than 25%. The next change that came with 3182 is that minimum lease terms can only be as high as 30 days. So this would prohibit associations from having minimum lease terms such as 90 days or 6 months or 1 year, which is commonly found in many sets of governing documents that usually after they've been amended once or twice, but even some developer documents will have minimum lease terms in excess of 30 days. So if you do have that type of restriction in place that is greater than 30 days, that's going to need to be adjusted. Going forward, as associations consider whether they want to regulate lease terms, they can now only go as high as 30 days. So this still allows associations to prohibit or further restrict short-term rentals. So that's still within the realm of possibilities, but now it's going to be at 30 days. The next change that came with 3182 is you can no longer require a minimum ownership requirement before an owner can rent. So for example, some governing documents require that an owner own for at least 1 year or 2 years even before they're allowed to rent out their unit or their lot. That is no longer allowed. So for associations that have that minimum ownership requirement as a prerequisite to renting, that would have to be removed as well and can no longer be enforced. And finally, the law changes what we're now calling the legacy date. It's commonly referred to as the grandfathering date, but the more appropriate term to use is a legacy date or a vesting date. Previously, up until 2012, when a rental cap went in place, it applied to everybody, current and future owners. After January 1 of 2012, when a restriction went in place, it only applied to future owners. It didn't apply to existing owners unless they consented to be bound by that restriction, which would not be very common to have that happen. The law took out that cutoff period in 2012 and says effectively, anytime a rental restriction goes in place, it only applies to owners who take title after it. So that'll affect documents that were amended prior to 2012 that had a rental restriction in place. And then going forward, it's going to be impacting the legacy date for when you have to change that document. And I'll explain that a little more on our next slide.
Actually, we're going to pause you for a minute, John. You already have a bunch of questions. Darren, do you want to throw some out there while I move to the next slide?
Yeah, so let's start with why do the governing documents have to be amended?
That's a great question. AB 3182 goes into effect January 1 of 2021. So after January 1, you can no longer enforce anything that violates those topics that we just covered that are shown in this slide. So if you have a minimum lease term requirement greater than 30 days, you cannot enforce it starting in January. If you have a rental cap that is lower than 25%, you can no longer enforce it starting January 1. In addition, the law requires all associations to amend their governing documents by December 31 of 2021. So you have a year to get these changes in place. The law mandates it. So it's not like some changes in the law. For example, solar panels has changed over the years. There was never a requirement to actually amend documents to conform to the law. The law simply said any governing document that goes beyond this law is considered void and unenforceable. This bill says you must amend. And part of that is because when people buy in a common interest development, they get the CC&Rs and they're going to see restrictions on rentals. And that could have the effect of preventing people who may want to close or purchase a home if they see there's a rental cap in place or an extensive minimum lease term. So it can actually deter buyers. And that's one of the reasons, there could be others as well, why you're actually required to get the amendment completed by December 31.
John, so question, does it affect it if there's restrictions on just renting a portion of the home, like a room?
That's a great question. And there's nothing in the law that says you could not prohibit a room rental. Whether that's reasonable or not would be a question for each association's council to ask if a prohibition on room rentals is considered reasonable or not, because the law does still allow for reasonable restrictions in place. For example, requiring homeowners to provide their tenant's contact information, a copy of a lease. A lot of those same minimum restrictions can still be in place. But the question is whether or not that would be reasonable, and that would be a question for each association's attorney.
And we got one more on AB 3182 about, does this law, my apologies, affect lending requirements? So for example, if you had lenders saying there has to be X number of rentals within the community, or less than that number, they won't make the loan.
That's a good question. And the law does indicate that if there are requirements you have to meet to satisfy lending requirements, you could potentially go beyond this 25% cap or 30-day minimum lease term. But it's really going to depend on a case-by-case basis. And I'm not aware of a lending institution that would require a owner occupancy that would require less than 25% rentals. Usually the minimum rental owner occupancy ratios for example, FHA or VA financing are usually at around 50%. So this still is going to go pretty far beyond what most lending institutions would require, but there is a possibility for going further if it's required. And that would be another question for each association's council.
John, I have two questions that came to me privately. So the first one is simply if amendments are subject to an owner vote, how does that apply if the law mandates you must amend? What do you deal with the vote?
That's a great question. And I'm going to wait on that one. Brad's going to cover that in a little while. We'll go into a lot of detail on that because I know that's a big question for a lot of folks.
Okay, and then the last question, there's a few specific, but to a general question, does this apply to cooperatives?
Well, if it's a stock co-op, it is subject to the Davis-Sterling Act. And so yes, the answer is it would apply.
Okay, so anything others more specific than that, somebody could talk to their counsel about.
Yeah.
Okay, I'm going to move to the next slide.
Okay, so we covered quite a bit of this, but these are all going to be required changes that you have to make to your governing documents. By and large, it's going to be changing your CC&Rs because that's where you're going to find most of this. But every once in a while, an association will have a set of rental restrictions in a set of rules that were adopted by the board. So in that case, it would be a rule change, but I would say for the most part, it's going to be amending the governing documents, the CC&Rs, to increase a rental cap to at a minimum, or at a minimum 25%. So you can go allow more rentals than 25%, but you can't go lower. And then decreasing your minimum lease term to no greater than 30 days and removing any minimum ownership period requirements. So that, again, that 1 year of ownership or 2 years, those are all going to have to be taken out or modified to conform to AB 3182. Well, the question then is what happens with the legacy date? For example, if you had a rental restriction that went in place in, say, July of 2011, usually by the language of that document, it's going to apply to all current or all future owners, but it may apply to current owners, but that's going to depend because it was pre-2011. But let's jump ahead 2 years forward. In 2013, you put a rental restriction in place that capped rentals at, say, 10%. In 2013, that applied to only future owners. Any existing owners were considered legacy owners who were allowed to continue renting regardless of the rental cap. Well, now with that 10% cap, you have to change it to get it to go up to at least 25%, if not more than that, but 25% is where you could go. What that's going to do is it's going to reset your legacy period. So anyone who had purchased after that restriction went in place in 2013, they were all under the cap originally. Now, 7 years later, 8 years later, you're putting a new restriction in place because it's being redone and re-recorded. Now the legacy date's going to apply as of 2021 when that new restriction takes place. The same thing could apply to really any rental restriction that was put into effect in the past. You're going to have a reshuffling of who is allowed to rent and who's no longer allowed to rent, because the law now applies to any rental restriction, even retroactively. This is going to have a big impact on associations that currently have a wait list. So again, using my example of a rental restriction that went in place in 2013 that had a 10% cap, there's probably a wait list of all of these owners who are waiting to rent once units turn over and someone is no longer renting or they sell their unit. Well, with this, once the new restriction goes into effect, or rather even after January 1, everyone on that wait list is now eligible to rent. So it's really going to make a big difference in your community. You're going to be almost starting over, or you are going to be starting over on a new wait list. So there's a lot of implications on that. There's a lot of nuances, and I'm sure there's probably 20 different specific questions that each association is going to have about, well, what about this person? What about that person? So it's going to be very important to work with your legal counsel to determine how do we deal with the wait list, who's now eligible to rent, how are we going to document that? Because it's for managers who are used to dealing with a rental restriction and a wait list. You already know it's a big administrative task to monitor that, to enforce that, and to deal with that. It's really going to add a lot more to that because you're really going to be changing the entire system and having to start over, and then notify homeowners about that because it's going to be new information for everybody. So what that'll mean is effective January 1, it could already affect your wait list, or at least once you record a new restriction to conform to 3182, everybody who's an existing owner now is going to be allowed to rent, and only future owners who take title after that new date are going to be under the cap. This is going to be important for associations who don't have a cap in place to decide, is it worth putting a cap in place now, or at least if they do, because there still is value in a rental cap. just understanding how it's going to affect them, and that if they're trying to cap rentals at 25% and they haven't in the past, it's going to take several years to finally get that number down because of all these legacy owners who are always going to have the ability to rent going forward.
John, there's a really great question. If an association doesn't have a rental restriction, is this requiring that they do have one? Do they still need to amend their governing documents if there's no rental restriction mentioned?
That's a great question. If you do not have a rental cap in place that's lower than 25%, if you do not have a minimum lease term greater than 30 days, and you don't have a ownership requirement as a prerequisite to being able to rent, then the answer is no, you don't have to do anything. If your governing documents don't deal with rental caps, lease terms, or ownership requirements before someone can lease, then you don't have to do anything. You don't have to put one in place. You're not required to have any restrictions on rentals, really. But if you do have them, then you have to conform to this law. So for a lot of associations, this requires nothing at all. And it's really just something to be aware of if they ever want to consider adding these restrictions in place.
Okay, we have a couple more questions. Darren, do you want to tackle some?
Can you limit the time frame someone can rent? And so that's an interesting question.
So I guess the question would be, could you allow someone to say rent for 2 years and then they have to take a year off and then they can rent for 2 more years? I don't think that would be considered reasonable under this law. I think because of the implications that would have on someone's ownership. For example, if they were an offsite owner and they had no intention of ever moving back, they would just basically have to let their unit sit empty for a year. Or if they were an offsite owner and they had to move back every couple of years. So I don't see that being reasonable under 3182, but it would be a question for each association's council to determine how that would work and what that would look like. But I don't think that would pass muster under 3182.
And I think that's a great answer. And another great question came in. If you lower the percentage from 30% rentals to 25% rentals, do you need a membership vote?
I think, is Brad covering that, or is that coming up?
Well, yeah, I think Brad would be covering that. That's not required. If you had a cap at 30%, you don't have to do anything. But if you wanted to drop down to 25%, then I think the answer is yes. You'd have to get a membership vote to make that amendment.
Okay. Are we ready to move on to the next slide?
Well, actually, I have one more question that's kind of interesting, because the question is, does this new law allow short-term rentals? And I'll leave that to John to answer, but I think fundamentally that is kind of, if you don't act, that could be the result.
Well, yeah, that's right. There is an argument, and it's not really clear under the law, that if your current documents don't conform to 3182, are all of your rental restrictions on lease terms, percentages, or are they all invalidated? And there's an argument that that's actually the case, rather than, are they only invalidated down to the thresholds that you're allowed to have, versus are they wiped out altogether? And it's not really clear under the law how that works, but potentially, yes, if you don't deal with this and get to a minimum lease term of 30 days, then short-term rentals are a possibility in your community. So it's important to act and to take action on this bill. Brad, I'll hand it off to you now to talk about amending to conform to 3182.
Very good. Thank you, John. So let me underscore a couple of things. And in particular, what John said, and that is that you're going to need to consult with your attorney, and that you may have 20 questions with your attorney, and that things are unclear. And this is a very unclear and confusing law, especially when it comes to the legacy dates. Legacy dates, that's the new name for grandfathering. And there is discussions amongst the community association attorneys in California, and it's really giving us fits. There's trying to parse these two statutes, the way it was written, how the CAI was cut out of the amendment process, the legislative process, how the fact that 600, oh, my screen just went blank. Can everyone hear me okay?
Yes.
Okay, very good. So my screen's blank, I'll deal with it. There we go. And so many questions. Now, this first one is a real gray area, and that is the law requires associations to go ahead and amend their rental restriction governing documents if they're not compliant. And as John said, if you have a rental restriction that's lower than 25%, or if you have a minimum lease term that's greater than 30 days, or if you have an owner occupancy requirement, you're going to need to amend your governing documents. It's a requirement, it's a mandate. And so where are these rental restrictions usually located? They're located in your CC&Rs, association CC&Rs. And so what is necessary in order to amend CC&Rs? It's a member vote. So how easy is that? Member votes for anything are difficult, let alone for a CC&R amendment, let alone for a rental restriction amendment, and let alone to try and get the owners to approve a CC&R amendment. So it becomes very difficult. What if an association fails? What if they go out, they spend all this time, spend all this money, and they don't get the votes? So what happens then? The law is unclear. What you're going to hear in a couple of seconds from me is how an owner who sues the association for failure to comply with these new laws, they can get penalties imposed against the association and damages for the willful failure of the association to comply. Willful meaning intentional. So maybe an association is going to be able to argue, hey, we made a good faith effort at trying to go ahead and amend, but we failed, so we shouldn't be subject to any kind of monetary penalty. And maybe the court will say, we'll go try again. So it's really difficult to see. Now, what about the idea of if we can't get a CC&R amendment to go ahead and change and comply with the law, what if we do a board rule? What if we go ahead and have the board make an association rule? And as we know, an association can go ahead and make rules simply by a board vote. So that's a thought too. But then what would you end up with? It doesn't seem very satisfactory that you would have a rule that is in compliance with the new law, and that you still have a CC&R provision, right, from the past that is inconsistent with the rule. So now you have this competing provisions, and it could come to a head when an owner comes to the association per law and says, give me the documents I need to go to a purchaser. And those documents are going to include a rental restriction. So perhaps the rental restriction will be the rule, and it could have a lot of verbiage about how it is not consistent with the CC&Rs that you're going to get as well. So it's is an issue. Going now to that same homeowner who says, well, that confused my sale, that cost me money. An owner could sue an association, and they could get a penalty imposed against the association for up to $1,000, for a willful violation. Again, the association can come into court and say, well, we made a good faith effort to go ahead and amend our documents to try and comply, but we didn't, so we should not be subject to a $1,000 penalty. In addition, what this new law provides is that an owner, if they sue the association for a willful violation by the association to comply, they could get actual damages, also known as compensatory damages. These are an actual monetary loss by an owner. What would that be? That might be loss of rents, right? Or diminution in property value. Hey, before our association only had X amount of rentals. Now we lost the right to restrict and we have a ton of rentals and my value went way down. Well, then the association would be able to defend itself, I believe, as well, in that, well, it's not a willful violation. So then one would have to pause to think, well, if someone were to sue the association and there is no willful violation, so they don't get compensatory damages or a penalty, then what remedy would they get with the court if it was just a good faith failure to get the amendment? So maybe not. Maybe there's not any kind of imposition of penalty or damages against the association. What about attorney's fees and costs? So this is the tail that wags the dog in almost every case between an association and an owner. There's no particular provision in this law about attorney's fees and costs. However, if an owner is going to be challenging the enforceability of a governing document, then you're going to look to the fact that the Davis-Sterling Act says that in any kind of lawsuit between an owner and a association regarding enforceability of the governing documents, the winner gets their attorney's fees. And just so you know, otherwise, unless the Davis-Sterling Act had that provision, a homeowner suing an association, if there weren't any provision in the CC&Rs, the winner is subject to their having to pay their own attorney's fees. It's only if there's some particular provision in CC&Rs or the law that shifts it, fee shifting. I think that about beats up the rental restriction law. So let's now.
Actually, Brad, I got one question I think we kind of conclude on is how long does an association have to update their governing documents? I know we talked about that earlier, but it'd be a nice one to wrap up with.
It would be. So it's 12/31/21. That's the time limit. So that part's clear.
Yeah.
Okay. All right, so moving on to getting out of the realm of the rental restriction, there's a couple of statutes, new laws that we're going to talk about, and we'll close up with a couple of fun ones before we go on over to Roger for some interesting cases. So the next couple ones are primarily for those associations who have employees and for management companies as well, because of course management companies are going to have employees as well. So this one concerns workers' compensation, and workers' compensation is that separate remedy for employees to go ahead when they get injured on the job. It's separate from your typical personal injury cases. That's separate because you don't want, by policy in the United States, we don't want employees suing their employers all the time and interrupting commerce in our economy. So basically you get injured on the job, you got workers' comp, and it's an easier process, less confrontational. Otherwise you get injured outside, it's personal injury lawsuits. So this provides, it's actually going to be in the labor code 3212.88, and it provides that employees who do not work at home, so this isn't for those employees who work at home, who do not work at home, who get COVID during an outbreak at work, are entitled to remedies under workers' comp. And so interesting definition of outbreak. So again, you know, I don't work at home, I work in the field or in an office, and I get COVID, and can I get workers' comp? Well, you can if your company has less than 100 employees. Then if 4 people at work get COVID, then it's considered an outbreak and you could get workers' comp. If there's more than 100, then they say 4% must. And then the other scenario where you could get workers' comp if you get injured on the job, you just injured, it's not necessarily on the job, but there's a presumption, is if OSHA shuts down your work. These new laws interrelate, so I'll talk to you about OSHA shutting down a place of employment in just a second. So there's what's called a disputable presumption in court that if someone gets COVID, under those circumstances, then it's presumed they got it at work, they get workers' comp. The employer, they can indeed though, they're able to go ahead and try and disprove that and say, no, you got COVID outside of work, maybe at a restaurant or something like that. In order to get the workers' comp, first the employee has to go through, exhaust their sick leave benefits and any other benefits that they have. When this happens though, when an employer, and this is all going to be in effect January 1st, this is sort of a serious one, and that is if someone gets COVID at your company, you're an employer, and you do not report to your workers' comp insurance, then you can be penalized $10,000 by the Labor Commission. So this isn't a chump change, 10 grand for that. Assembly Bill 685, moving on to that one. So what I mentioned this a second ago. So this is a OSHA, Cal OSHA, and occupational safety and governmental entity, and they can go ahead, beginning January, and they could shut down particular places of employment. Let's say there's several branches of a management company. In one of the branches, someone gets COVID there. If OSHA, in their opinion, believes that there's an imminent risk of there being a breakout of COVID, then they can go ahead and they could shut down that place of employment. They would then require the owner to post a sign at it, and also to let everyone know how the company, the management, is going to go ahead and clean up and disinfect it. Fun stuff, huh? Moving on to the next slide, please, is a little less heavy. So this is a new law. Again, it's starting in January 1st, but there's a 1-year grace period. So a grace period for debt collectors to get licensed. So debt collectors in California are going to have to be licensed. It's going to be called the Debt Collection Licensing Act. It's in the Financial Code of California. 1-year grace period. So this is for those management companies who actually do some assessment collection work, and also for our industry's assessment collection companies as well. They need to be licensed. Now let's harken back, next slide, to ADUs. ADUs are not going anywhere? Absolutely. Accessory dwelling units. Let's step back a pace here and make some foundation for a discussion about this new law. And recall that this came in, I believe it was last year, in that we all learned what ADUs are and JADUs. ADUs are those separate dwellings that someone could go ahead and they could construct on their lot, not a condo, but on their PUD, on their lot. And they could go ahead and it would have separate living, eating, sleeping, cooking, and bathroom facilities. That qualifies for it. It could be part of the home itself, like an attic, or separate. And a JADU, another term we need to know. So that is 500 square feet or less. Same thing as an ADU, except that it has to be part of the home and it doesn't necessarily need to have bathroom facilities. So when an owner goes to the local building department to go ahead and get permission, right, to go ahead and build these, this new law provides that the local building department, that they have to do it ministerially. What does that mean? They have to do it quick and dirty. They can't mess around with a lot of paperwork and a lot of time. And furthermore, if the building department does not approve or disapprove within 60 days, right? If they don't act within 60 days, then it is deemed approved. So someone goes to the building department to do an ADU or JADU, it's gonna go through pretty darn quickly. And moving on now to some sort of, I guess, interesting types of legal information. So the next slide is about shocking tires. So this has been going around in the industry. In particular, the premise is that you probably all experienced this, and that is you park in a city, in downtown somewhere in some city, and your tires get chalked. Your tires get chalked by the local municipality, so they could determine how long you've been parked there, right? So you park there too long, you're going to get a ticket. And in Michigan, a person got very riled up, and supposedly it's a feud between them and the parking meter person. And they made a federal case out of it, literally. So there's a federal case, it's ongoing, it's not complete. In the middle of the case, the 6th district, it's over in Michigan, and they made a ruling. They said, well, gosh, chalking tires, this is a government entity, and they were actually chalking some private person's property. Well, this is a violation of the United States Constitution. The 4th Amendment is protection against unlawful searches and seizures. That is a search without a warrant, a search without a warrant. And they're saying, that's exactly what this is, the court said. And so people glommed onto that, and there's articles on the internet about it. And the law, because it's the 4th Amendment, it's I'm going to tell you my opinion. It's limited to the government action. And furthermore, it's over there in the Sixth Circuit Court of Appeals. It's not even in California. So I do not think that this applies to an association who chalks tires in order to determine how long someone's been parking there. Wrapping up is a preview of coming events, potentially. So we all love video conferencing for meetings. I think it's fantastic. It's really saving associations a lot of money. This is my little commercial. I'm advocating for it. I think that we're really efficient. What did Roger say? He's literally doing this presentation, then he's going to go to 2 meetings today. Wow, I mean, how efficient can that be? That is super efficient. So the California Law Revision Commission might be, there's no guarantees, they might be making an amendment to the definition of a board meeting in the Davis-Sterling Act, in the Open Meeting Act portion of it, that provides for deleting the requirement that you need to have a particular physical place for an owner to show up to, and that there be a board member or a representative of the board also there. That's the current requirement. And obviously because of COVID, if any owner went into court and said, well, you didn't do that, you didn't have that physical place in addition to the video conferencing, I think they would lose the case, but that may come. So that's the end of, hope I didn't go too long, but that's the end of the statutes, and we're going to hand it over to Roger for some fun new cases.
There were a couple questions in the chat. I'll just throw them both out there. The first one was, if an association is 100% single story for the ADU, could they add a second story? And I don't know if that's just a second story to their home or if it would be an additional unit on top. That's the first question. And then the second question was, with regard to the chalking of the tires, would they just then be forced to chalk like on the pavement behind the tires so you could tell if it was, I guess, moved unless it was erased? So I don't know who wants to tackle those.
Well, let me give it a shot for the first one. So what a great question. The owner, so we have an entire development, right? That is completely one story. And so someone's going to jump out there and throw a second story up there. I think we can't give you a for sure answer, but I think that barring any kind of, I know I'm sort of shooting from the hip, but these ADU laws are so permissive. They're pushing ADUs, and one of you guys could chime in. I think that, regardless of whether it's visually unaesthetic, I think the push would be that, hey, if there's no restriction on this, then you got to allow it. The attorneys for associations, we do policies for ADUs to address the aesthetic issue. I would think you would have a tough row to hoe to go ahead and try and say that isn't allowed. Boy, that just seems so odd. What was the second one? The second question?
About chalking tires or chalking the pavement behind them instead. Would that be like the preferred method?
Oh, yeah, there you go. Look at that. They're very smart. So you would, that's how you get out of it. Now there's absolutely no way you can say that's an illegal, at least according to this court, because the whole point was that you put chalk on someone else's vehicle, chalk on the street. Well, that's whose property is that? That's the person who's doing the chalking.
And then there's some very specific questions that are in the chat and that are also coming to me privately. So if we don't ask your question during the presentation, could you hold the really specific ones, like a mixed use HOA or a very specific location for an association, and ask it in the Q&A afterwards, just to make sure that we get through all of the information? That would be super helpful.
And let me just clarify too, just remember, this is general informational. And normally we lead with that. And I just want to remind everybody, the attorneys cannot answer really specific questions. I know that there are 2 out there, one on a mixed use, one on a property where it's owned by an organization. Generally speaking, the best advice we can give you is please speak to your attorneys. They'll be able to answer your very specific question appropriately and can advise on your specific facts, because our attorneys today really are limited to a general discussion, providing information about the new laws, helping you to know where the big guideposts are in the law, so that you have an opportunity to speak with your own counsel about those issues. But fundamentally, our attorneys can't answer that level of specificity. So for example, how exactly should you enforce your parking restrictions? You should be discussing those issues with your own attorneys, because there are many different issues there. And so we won't be generally answering very specific questions. Usually it's more the broader questions that the attorneys can address for you.
Okay, moving on.
All right, now we're going to talk about new case law. In 2020, there were very few new cases in California dealing with community association. And we're going to blame that in part on COVID-19. A lot of the courts are shut down still. So we have one case from California that was interesting, and the rest of them we looked at just weren't very interesting. So we also looked at the federal cases from 2020, and we're going to present a couple of those that deal with discrimination that are very interesting and very applicable to community associations. And we're going to start out with a case from late 2019 called Davis versus Echo Valley Condo Association. So Phyllis Davis purchased a second floor condo unit at Echo Valley, and she suffers from asthma and chemical sensitivity disorder. The downstairs unit, which was owned by the Lamnins, was rented out to a smoker. He was a cigarette smoker, not marijuana, and he smoked regularly in the unit, and Ms. Davis started complaining to the association about this constant smoking was aggravating her asthma. So next slide. The association took several steps to address the situation. They asked the tenant to smoke outside instead of in his unit. He said no. The association had a HVAC contractor install a fresh air system on Davis's ductwork, and the association actually paid for that. And it was an expensive system. None of these steps satisfied Phyllis Davis, and she would make a log of every day and time when she could smell smoke. And she presented that to the association. And after a short time, Ms. Davis sued the association. She sued the downstairs owner, she sued the downstairs tenant, and of course she sued the management company. And she alleged discrimination under the Fair Housing Act. She sought damages and a complete smoking ban in the community, saying, because of my asthma, the association is discriminating against me. Next. So after the litigation commenced, the board took some further action. They tried to pass an amendment to the CCNRs that would prohibit smoking and make the entire condo complex a non-smoking complex. That amendment failed to pass. They couldn't get the vote. So that was the last thing that they could do. The lower court rejected Davis's claim and dismissed it. And Phyllis Davis appealed to the Sixth Circuit Appellate Court. That court affirmed the dismissal of her claims, and their reasoning was that this is not a reasonable accommodation under the FHA. This request would have required a fundamental change in the association's smoking policy, not just a moderate adjustment to the policy. And they said that a complete smoking ban would intrude on the rights of third parties, and that obviously a majority of the people at the association were not in favor of a smoking ban. Next slide. The court did, however, give great weight to the fact that the association didn't ignore the request, and they sought a compromise. And if you're managing an association or representing an association that has a Fair Housing Act complaint, the courts want to see some response. They don't want you to just ignore it. They want to see a dialogue, a communication with the person making the complaint. They want to see some effort. And here we had a lot of effort. We had communication with the smoker. We had a purchase of a fresh air system for Davis Condo. And they went through the whole process of trying to get an amendment to ban smoking. So the court was very impressed with that. And I think that helped the condo association in achieving its win. So the holding of the case is that a smoking ban would have been a fundamental change to the association's policy, and the FHA only requires a moderate adjustment to policy. Also, a total ban on smoking would have intruded on the rights of the parties. So our takeaway is that the association should never ignore an FHA request. They should investigate, they should seek a solution or a compromise, and most importantly, they should get their general counsel involved so that they can possibly avoid a lawsuit like this, which can be very, very expensive. Okay, our next case is Hill versus River Run Homeowners Association, and this is a family discrimination case. So River Run is a large 333 unit single family association. They have a community pool, a rec center, tennis courts, clubhouse. And they had some rules that were on their face clearly discriminating against children. For example, the tennis court rules provide that adults have court privileges over children after 3 p.m. on the weekdays and any time on weekends or holidays. So the only time the adults don't have privileges over children is when they're in school. And the swimming pools required certain times for quiet hours. Next slide. Also, pool guests were limited to 6 guests per household, although children aged 14 to 18 were only allowed to have 1 guest. So there's yet another thing that you wouldn't think on its face was family discrimination, but this is what the whole case is really about. The association had a rule that you could build a fence in your backyard, but only a privacy fence between properties, and you could not enclose the back of that fence. So the Hills wanted to build a perimeter fence with an enclosed back to enclose their entire backyard because there was a creek in the back, and they were concerned that their children who were playing in the yard would wander out the back and drown in that creek. So they asked the association, they put in an architectural request, and the association denied it, even though they had approved at least 3 other applications for all enclosing fences. So after they denied the Hills fence application, the board modified their rules to even more strictly prohibit enclosing fences. So the Hills filed a complaint alleging family discrimination. And in response to that complaint, the board revised the terrible tennis court, pool, and rec center rules, eliminating restrictions on children. But they did not bend on the fence issue. So the Hills filed a lawsuit seeking damages and injunctive relief. The federal court looked at this and they rejected some of the arguments of the association. First of all, they said it's not relevant whether the Hills ever used the pool, the tennis courts, or the rec center. You may have intimidated from using those facilities by your discriminatory acts against children and families. And the court said those signs were discriminatory on their face. I mean, that's an easy issue, an easy win for the Hills there. The court also said whether there was an intent to discriminate is completely irrelevant. So you don't have to show intent to discriminate. They also said when the board came in and changed the ARC guidelines to defeat the Hills application, that was retaliation against the Hills, and they shouldn't have done that. So the Hills actually moved away from this association and moved to a more family-friendly community. So they never did build the fence. but they did win their case. And the takeaway here is that all rules and signs and policies should be reviewed by your general counsel for discriminatory content. I think most of the managers and everyone in the industry could have told them that these signs are not good and you shouldn't have those up there. But one place we don't really look at family discrimination issues is when we're reviewing architectural applications. So think about this case every time you have an architectural application and consider what effect does it have on children? Because the court felt that the association's failure to allow these children to be protected from drowning in the creek was indeed family discrimination. Also, we want to educate the board and committee members regarding discrimination in housing issues.
Okay, Roger, there's a couple of questions.
Sure.
One was for the first case that you talked about. Were attorneys' fees recovered in that case?
That case did not mention anything about attorney fees being recovered.
Okay. And then there's a question and kind of an answer, but I'll throw it out there anyway. Can a senior community have rules that limit access to children with regard, like specifically the pool use? If it is a senior community, can't they limit access?
Yeah, different rules apply for a senior community. They can certainly limit access, and if you're a community over 55, they have different rules. So
Okay.
In most cases, they can discriminate against children, but there are limits to that as well. And again, that's a general counsel issue specific to the Elder Association.
Great. Those were questions that came to me privately. Darren, I don't know if there was anything else in the chat.
That's all that we have.
Okay, moving on.
Right.
Oh,
Let's now look at a California case in which attorney fees were awarded. Coley versus Eschaton from 2020. The Grass Valley HOA has 130 single family homes and 137 rental units, apartments. The developer Eschaton owns all of the rental units. So their ownership of a majority of the units provides them with a perpetual majority, 3 of 5 seats on the board of directors. So the board members that were elected by Eschaton's votes were salaried employees of the company Eschaton. So everything was fine for the first 10 years of operation. The cost of security and emergency response services were split equally between the single family homes and the apartments. Then after 10 years, by a 3-2 vote, the Eschaton board members voted to charge 83% of those costs to the residential units and only 17% of the costs to the rental units, which were owned by Eschaton. Coley was on the board, and he of course voted against this new allocation. And he actually filed a lawsuit against Eschaton saying that allocation's not fair. He alleged a breach of fiduciary duty against the board members personally and as a board. And the case went to trial. And the trial court found that the Eschaton board members had an irreconcilable conflict of interest here because they were paid by Eschaton, and their pay was also based on the financial performance of the apartments. So anything they could do to save the apartments money ended up increasing their pay. Is that a conflict of interest or what? Also, there was no explanation of the 83% versus 17%. They could not explain how they came up with that number. They could not show that the residences required more services than the apartments. They just basically pulled that number out of the sky. And the trial courts found that the individual board members for Eschaton were personally liable, but said only the corporate defendants were responsible for payment. And the trial court awarded attorney fees to COLI in the amount of $654,000. That's a lot of attorney fees. So the Eschaton group, the board members who worked for Eschaton, appealed to the appellate court. The appellate court said, because of the conflict of interest, you board members had the burden to show that these approved assessments were just and reasonable, and you provided no evidence to show that there should be a reallocation. The appellate court also said that we know the business judgment rule protects a director with immunity for decisions made in good faith, but that immunity is not going to apply when you're acting under material conflict of interest. So you're not protected by the business judgment rule if you have a conflict of interest. So the appellate court's analysis was that a director may be liable for breach of fiduciary duty, even if the director did not personally benefit from the breach. And these board members were personally liable for damages resulting from their breach of duty because they had a conflict of interest, and they should have abstained from this vote. Our takeaway, board members should always be encouraged to disclose any potential conflict of interest, and they should recuse themselves from voting on any matters in which they have a conflict. Also, the business judgment rule doesn't always protect a director from personal liability. If that director doesn't act in good faith, or they act with a material conflict of interest, they're going to be personally liable. And in this case, we're looking at a huge liability, $654,000 in attorney's fees before they even got to the appellate level. So this is almost $1 million in damages just for attorney fees. So remember those things about conflict. Always advise your board members to disclose conflicts and recuse themselves when they have a conflict. Any questions come up on COLI?
Yes. Darren, do you want to tackle these?
Well, this one I don't know that we can answer because it's a question about, did the governing documents allow for a variable assessment split? And we're not able to answer that question because it's limited to just the appellate opinion and the findings that the court made in their opinion. But Roger, if you have any insight on that.
Well, I think even if they did, you would still have to justify the adjustment in that split. If you could show that, you know, these services applied so much more to the residences than the apartments, you may be able to justify it, but they still had a conflict in voting on it. And I don't think that anyone could justify the 83% to 17% split. That's just huge. But even if they could, 3 people wouldn't have been able to vote on it, and it probably would have stayed at 50-50 anyway.
Okay. Well, it is now our question and answer time. So we had talked about opening this up if people want to ask questions, since there's no more in the chat. I will stop the screen sharing and people can go on video and ask you their questions directly if there are any.
Is this going to be the quickest legal forum ever?
Yes.
I don't know. Becky Jolly has a question. Becky, can you go on and ask it? Because I don't understand it. Sorry. It said, would it not be defeated if it was not allowed to begin with, and potentially, and then George Hicks has a question after Becky's. Becky, are you there?
Yeah, I'm here. So on the Connolly case that was just there, if initially they weren't allowed to have a split assessment, wouldn't it immediately be defeated because they've now violated the governing documents? So why go any further? That's why I wanted to know whether or not it was in the governing documents to allow for a split assessment. And that kind of pertains to other things within how we work legally.
And it probably was allowed in the governing documents, or it wouldn't have went as far as it did. And I never saw that argument raised by any of the parties in the case. So I'm assuming it was allowed.
And the bigger issue with the case is the material conflict of interest that the directors have. right? And I think that's the biggest takeaway for everyone is people need to fully disclose. And when you have a material conflict, like for example, your pay is based on a benefit that you might receive from a decision the board makes, those are absolutely the times to step away and not participate in the discussion or the vote on those issues.
And we have meetings often, a couple times a year, where the developer's still on the board and the homeowners on the board are considering a construction defect claim. And the developer rep on the board will actually show up and try to participate and vote on whether or not the association should sue the company they work for. And sometimes they won't listen to reason, saying, you have to be excused from this meeting, this conversation. You can't vote. You have a clear conflict. Many times they will understand that and leave the meeting. But I had someone just last month who got very angry with me and said, well, I hired a babysitter and everything to be here, and now you're telling me I can't be in this part of the meeting. And I said, well, that's correct. You have to leave. So you do run into it often when there are developer reps on the board, or in this case, an apartment owner on the board.
And then George Hicks had raised his hand. George, are you there?
Yes, Wendy, I am.
Great.
A question, a general question to the legal counsel here present. I'm always amazed when I hear these results of civil cases, and where I find that there's an obvious conflict of interest, but apparently the legal counsel for the individual who represents the conflict of interest somehow still pursues these issues. And I'm curious as to, are these things monitored by the Bar Association, or are these things that, am I being naive, assuming that the legal professions doesn't discover these things ahead of time? It just seems a little odd to me.
Well, I think you're right. And any of the attorneys on the panel could have told the parties how this was going to turn out the very first day, before we billed $654,000. It was pretty clear that this was a conflict, but the state bar does not monitor or go after the attorneys for zealously representing their client. This client apparently thought they were right. But the state bar doesn't go after attorneys unless they're doing something very egregious. Look at the criminal defense bar, for example. Most people that go to trial for criminal complaints are guilty, but they still deserve representation. So it's not the attorney's fault. I think if it had been me, I would have told them the first day, this is a losing battle. You're never going to win. So save your money and just fold your cards. But they didn't do that for whatever reason.
Well, I understand that, I guess, because it's it's legal counsel's responsibility to ensure that the individual's rights are protected, whether or not their claim may be valid. So that makes sense. Thank you.
I have a couple, again, I think they're pretty specific questions that are coming to me privately. They're not going in the chat. So I'll throw them out there and you guys can just, Darren, you're really good at saying no. So I'll let you handle it.
I'm not going to say no. I'm going to say there's a better answer someplace else.
Awesome. Okay. So let me give you two of the ones that I think you're going to say that too. When our government,
there's a better answer someplace else. Next question. Kidding, Wendy.
When governing docs were rewritten, all mention of members' annual meeting was removed, and it was replaced with referencing to strictly a tabulation meeting. Can annual meeting be reinserted? And if anyone,
I think what you would do there is that always remember the law prevails over our governing documents, right? If there's a conflict. So if our documents are silent on that, the Corporations Code directs associations to hold at least one annual meeting, right, each year. Of course, there's no penalty for not doing that. And the association's board, as fiduciaries acting on behalf of the association, should just go ahead and proceed with calling an annual meeting and calling the tabulation meeting their annual meeting. Because in essence, that's what it sounds like they're actually doing.
Good answer.
And then my next question, I don't know if this is for
And we
a
do answer questions, Wendy.
That's great. I'm really good at asking them. So this next question, I'm assuming, would be very different for a condo versus a PUD, but it's a new board member. This is the first time she's attending. And they have a neighbor who cooks with heavy oils and meats with the char and smoke that invades a home. Are they allowed to ask them to update their venting system? They don't even know if it's possible, but is it something that the association can ask the homeowner to do as opposed to doing it for someone like in Roger's case, is assuming where this is getting referenced?
I think Roger has a great answer for that.
Yes. Are they alleging discrimination due to a disability, or they just not like the smell of what's cooking? Does anyone know? So that makes a difference, but we deal with a lot of high rises, and you can always smell everything your neighbor's doing. Not everything, but a lot of things. You can always smell what they're having for dinner. You can smell what they're smoking. So I don't think requiring someone to update or reconstruct their vent system in their home because you don't like what they're making for dinner, I don't believe that's reasonable.
And I got in a message, that was the situation.
And I have a neighbor in my high rise that cooks onions all the time. I don't care for that smell, but other people love it. So it's a common problem, but we can't stop someone from cooking the things they like.
Okay. And then, well, there's so many more coming in, sorry. I'm going to finish this one and then I'll go back to all these people sending me private ones. You can put them in the group chat too, so Darren can help monitor if you want. What if there's, going back to the food question, yes, it was a smell issue, but if there's black soot coming down the outside wall of the building from the vent, could it be a potential fire hazard? I mean, how much does the board have to intervene at this point? And maybe that again is too specific.
Yeah, I would say talk with your general counsel on that issue. Okay. Because there could be discrimination issues. Think about perhaps this is a religious ceremony or cultural. And so talk with general counsel about this issue, because it's really, you're getting into the details and the nitty gritty of what should this board specifically do. And as we learned from Roger's case involving the Coley matter, the board really needs to think about it and wrap their head around what can we do here, and talking with their counsel would be the best option under those circumstances.
Perfect. Two more questions that have come to me. Someone asked if they missed the answer about the rental restriction CC&R amendment and having to do an owner vote or not, because it was posed, I know Brad addressed it, that you could be doing an owner vote, not get a quorum, not get the vote, and you still have a law that takes priority. So how do you handle that?
Yeah, so you're saying at the circumstances where the association attempts to go ahead and amend the CC&Rs through an owner vote in order to conform to the new law, because let's say that, let's put some meat on the bones of this one. So let's say that the association's current rental restriction cap percentage is 15%. And so that's too low. And the association then attempts to have the owners vote for 25%, right? They fail. And certainly the association cannot enforce at 15%. They can't do that. It's null and void. So therefore, what does it fall to? And that's why all these attorneys across the state are discussing this, because but should the board just go to a board resolution and analogize to, say, other parts of the Davis-Sterling Act that we're going to go ahead and make this an amendment anyway? Should they do a rule? Because they're going to there's going to be a lot of flack about, well, now we don't even have a rental restriction anymore. Is that what's going on? Or is our rental restriction 25%? What do we do with, as John said, what do we do with our wait list? There's two statutes. One was amended and one was adopted, and they cross-reference each other, and they don't give the answers that are going to make a nice, clean answer so that associations know how to proceed without risk.
Anybody have an opinion about amending the documents, that being the CC&Rs, without a member vote?
Just having a board resolution, huh?
Yeah.
Mm-hmm.
And then I assume potentially, and just remember this, none of our opinions are actually our opinions today, and they may change based on your circumstances. But just a general discussion. What if the board says, hey, we don't want to spend the money trying to amend our CC&Rs. We have to hire an inspector. We're going to wait forever to get a vote back. It's just never going to happen. And so the board thinks, I think it's just best if we just approve that amendment and re-record our CC&Rs with those revised terms.
Yeah, I don't want to monopolize it. What do you think, John?
Well, it's, I think you have to look at other statutes, because if you look at the anti-discrimination statute that gives the board the authority to amend governing documents, CC&Rs, to delete discriminatory practices, that code section specifically says the board can amend the CC&Rs. Similarly, when the code sections were all updated in 2014, that code section in Davis Sterling said the board can amend the CC&Rs to comply with the code. So you have times when Davis Sterling specifically authorizes a board to do this. AB 3182 does not do that. And as we can try and speculate as to legislative intent, but you have to presume, if it's not in the statute in one section, but it's elsewhere, that it was intended to not be there. So I think that creates a real problem for boards trying to amend CC&Rs to conform to the code, because AB 31.2 does not include that right, unlike other provisions in Davis Sterling.
I think that's what a judge would say.
Okay, a couple more questions. I'm
just gonna speak to Steve. I don't know that we can actually address the question, but let's kind of make it a little broader.
Okay.
Member wants to build a second story on their home as an ADU. Do you have any thoughts? Anybody on the panel?
Depends on a lot of things.
Yes, and see that's the issue that we're always going to be faced with, is there's just so many variables that could change and give you the correct answer. And so that's where it's always hard to answer these really specific questions. And we apologize for that. We'd love to answer it, but the better option is to speak with counsel about all the different variables that may be at play and whether or not that's a viable option to prevent that or to allow it.
Plus, you have such new laws, and so it's difficult to give us an answer about specific facts regarding the new law, because there has not been any courts that analyzed it and that gave us some interpretation.
Well, there's two kind of fun questions. I'll just throw them out there. One is, is there any thoughts on what if the association purchased air rights to protect views, and that would restrict the second story ADU? Kind of funny, kind of fun.
Are they allowed to spend the money on that?
Yeah, I don't know.
Right? That's the first question. Wouldn't you have to amend your documents to have the right to buy the air rights? And then how are you going to fund that?
Well, and you'd be buying them from the person who wants to build up. So why would they sell them to you if they want to build up? They want that air.
Yeah. Good point. And then Deanna Themelius asked a great question. Like, what's the true risk, if the board doesn't go out for the vote, but is amending their documents to comply with the law?
You go to HOA jail.
Perfect.
Get short-term rentals.
Yeah, it carries a civil penalty of $1,000 per violation. So anytime someone woke up and they said, hey, there's that rental restriction in place, I'm going to go to small claims court and get my $1,000 check. I mean, it could literally be, someone could be that arbitrary. But you could actually have actual damages. If you have a recorded document in place that imposes a rental cap and somebody says, I'm canceling my purchase agreement because this rental cap's in place, that seller's going to come to the board and say, not only am I asking for my $1,000, but you cost me to lose a sale because you failed to amend your documents. That sale cost me hundreds of thousands of dollars, and now I can't sell, or whatever the reason is. It could really come back to bite an association. So that's not one that I would roll the dice on. There could be unknown possible damages that an association could be paying. That, you know, it's one thing if the board does everything it can and still can't get the members to approve it. You know, as Brad mentioned, we have some better arguments to make in court as to why we should not be paying actual damages, but just ignoring the law is never a good option. But here in particular, the legislature made it clear they want this law complied with.
Well, and here's another one on the civil penalties. Is the violation per occurrence and per person, or is it a one-time for each owner?
Brad, what do you think?
Yeah, so first of all, the law doesn't say specifically. And so secondly, let's say the scenario that John just said, that each owner goes into courts in small claims. Small claims has no precedential value, so it could add up. It could be for each owner, how it affects them.
Okay. Looks like we might be done with questions. Thank you so much to our amazing panel and to my incredibly sarcastic and always fantastic co-moderator, Mr. Bevan. And I'll give it.
Pleasure to work with you too, Wendy.